Yes, call the next.
Item number 1. Item number 1 and item number 2.
The order passed by the Learned Additional Session Judge, Mal Jalpaiguri, dated 21st of August 2023, in Sessions case number 157 of 2015 is set aside and passed. The petitions are discharged from the Sessions case number 157 of 2015 in connection with Mal PS case number 655 2014 under section 302/120B of the IPC. The petitions are discharged from the respective L1.
Item number 3.
The imping order dated 4th May 2024 passed by the respondent number 5 is set aside and passed.
Grateful.
Item number 4.
अर्धली को है अर्धली को है
Item number 2.
So item number 4, I'm for the petition. This is my prayer for extension of interim order.
Yes.
This is the extension, the interim order was passed on by an order dated 5th of April 2024. I have annexed the order sheet at page 10 of my application.
Page 10.
Yes. Because I had already served the copy upon the opposite party's private opposite party wife.
Considering circumstances till 5th of May.
Yes.
Or until further order.
Yes, sir. The
So-
next date in the lower court has been
5th May. Today we are on.
today, on 24th.
Huh?
24th.
So
Next date is on 4th of April.
I am asking one question. This order is only up till the 5th May.
Yes,
Today we are on 24th of May.
yes.
So
So I have filed this copy order, application. I have filed this application,
for
extension.
where is the order? It can be extended. That has been elapsed on 5th of May.
Lordship, afresh can be given. Lordship, I have paid for either extension or afresh, Lordship. Extension, we have paid for extension or afresh.
Where from you came to know that in the criminal applications 2 players can be made?
Lordship, this is a complaint case. Complaint case.
So appearing for the petitioner. Petitioner has filed the affidavit of service. Let us semi copy the record. You are appearing for the state. You are appearing.
No.
None appears on behalf of.
Complaint
None
case.
appears on behalf of the opposite parties. Opposite party. Party. Full stop. The counsel for the petitioner submit that by an order dated 5th of April 2024, this court has passed an order for stay of the proceeding of CR case number 168 of 2023, pending before the Learned Judicial Magistrate, Second Court at Alipurdwar, till 5th May 2024 or further order, whichever is earlier. So counsel for the petitioner submit that due to some unavoidable circumstances. When the court was started, when the court is started, the big nothing. When he filed. No. Counsel for the petitioner submit that from 5th. No. Counsel for the petitioner submit that on 5th of May 2024. No circuit bench was available and only the court circuit bench started on 13th, and accordingly the petitioner has filed the petition on 15th of May 2024, either for extension of the interim order or for reimposition of the interim order dated 5th April 2024. Heard the Learned Counsel for the petitioner, as man appears on behalf of the opposite party in spite of service of notice. This court find that on the previous occasion, this court, after being satisfied with the case made out by the petitioner, has stayed the criminal proceeding. Accordingly, the Accordingly, the order dated 5th April 2024 is reimposed till 19th of June 2024. Grand number so and so disposed of.
Grateful, Lordship.
Item number 5.
I'm for the statement.
Lord, I am for the petition. Lord, I am for the petitioner, my Lord. I'm praying for extension of the interim order, my Lord, passed on April 29. But it is about to expire on 31st of May, my Lord.
Yes.
Lord.
31st of May.
Yes, my Lord.
No coercive action be taken against the petitioner in connection with proceeding with special GR case number. Who is for the state?
I'm for the statement.
Yes.
Lordship, sir, there is a case. They have filed one injunction applications.
No. What about the extension of the interim order? What is your submission?
Lordship, it will take time, Lordship, as because so many.
So and so appearing for the petitioner, so and so appearing for the state. Full stop. The petitioner has filed the present application being and so and so appearing for the opposite party number 2. Full stop. The petitioner has filed the present application being CRAN number 1 of 2024. Praying for extension of the interim order dated. Interim order passed by this court dated 29th April 2024, which is going to be expired on 31st of May 2024. Heard the learned counsel for the petition. Are the learned counsel for the respective parties. The interim order dated 29th April 2024, which is going to be expired on 31st of May 2024, is extended till 20th June 2024 or until further order, whichever.
Consider the period of extension, madam. Can you keep it on, madam?
Ready? I am ready.
The first week.
If you are ready, I am ready.
First week of next month.
First week when the court starts.
10th of June.
Okay. Till 13th of June 2020.
Lord,
Or until.
Lord,
further
there-
order,
Lord.
whatever is earlier.
my Lord, let
Ten
it be,
numbers
let it be,
substantive.
my Lord, since the court will reopen on 10. But let it be at least 7 days, my Lord, after the court reopens, my Lord.
Next.
Status appearance. Status. Obhijit Sarkar.
When they- Yes.
My lord, I appear for this petition, my lord. Kindly recall that is that matter regarding the pension, family pension to the second wife, not second wife, my lord, marriage during the lordship, yes. May I make one humble prayer? Kindly fix it in the next circuit. Why I'm telling you, my lord? I want to take one more chance. The question of family pension, I know there also it might.
As per the prayer made by the counsel for the petitioner, the case is adjourned. Let the matter appear before the next.
Great.
Item number
I beg to appeal for
My lord, I beg to appeal for the petitioner.
Yes.
The petitioner filed his writ application and police in action.
Yes, what are steps you have taken, madam?
Lordship, the
Already FIR is there.
Yes, my lord, just
So recovered, Lordship, I would like to submit the report.
Child recovered. And whose custody now child is?
Lordship, now they are present. Lordship.
only today the child is being produced before the CWC, as far as my instruction is. Can I have a copy? Thank you.
Lordship, I have already handed over the copy.
Yes. Excuse me.
Yes.
My lord, my grievance is addressed, my lord.
So what do you want?
My lord, let the application be disposed of.
Huh?
My lord, my grievance is addresses, the
So
petition.
you are satisfied with the report?
My lord, as far as my instruction goes, as of today, my lord, the child is being produced before the CWC. The petitioner is also present at this point of time. He is present before the CWC for taking the custody of the
So-
child.
Now,
And my lord, regarding the
now
other,
the child is in custody of your,
right now, he is being produced before the CWC.
Then you will
So
finally.
at the end of the day, I think he will be there before me. So 164 will be recorded. That is the procedure. My lord, I think my client's grievance is addressed by this.
So I am disposing of
My lord,
accepting this report.
my lord, as your lordship pleases.
So and so appearing for the petitioner. So and so appearing for the respondent. The petitioner has filed the present application. For not taking appropriate steps by the police of PS.
Bhaktinagar PS, my lord,
Lordship,
Yes,
under
Ashikar-
Ashikar outpost,
police outpost, Bhaktinagar.
under Bhaktinagar police
Bhakti
station.
Nagar Police Station. Though, in spite of registration on the FIR under section 420/468/425/307/328/385 506/34 of the IPC. This is the FIR,
My lord, this is the FIR.
but here it mentions something else.
Lord, there are two FIRs.
Hmm.
This is the second one. The first one being
So
that
the child has been recovered in connection with
in
this.
connection with this FIR, my lord.
Yes, this FIR, not in this case.
My lord, the FIR which is annexed with the report of the blunt.
Correct.
My lord, that is the FIR.
That is the. क्या बोला? What's the problem?
The present application from national police steps by the police.
Police authority, police stop. On the complaint made by the petition, but number 4, FIR number 4. Police stop. The additional government pleader, you are
I am led by learned additional government pleader, Lordship.
Leonard Council is appearing for the state, has handed over the report submitted by the Assistant Commissioner of Police, Siliguri, Metropolitan Police, East Division, -1, dated 23rd May 2024, forwarded by the Commissioner of Police, Siliguri Police Commissioner, wherein it reveals that on receipt of the complaint dated 20th May 2024, the police has initiated an FIR being 440 of 2024, dated 20th May 2024, under section 380/363/365/34 of the IPC. And during the investigation of the case, the victim, what is the age?
13 years, Lordship,
Huh?
13 years.
Victim who is aged about 13 years have been recovered on 23rd May 2024, and the minor was produced before minor has been produced before the child welfare committee, Jalpaiguri, on 23rd of May 2024, and they will take appropriate steps by filing an appropriate application before the Learned Court of Chief Judicial Magistrate, Jalpaiguri, on 24th May 2020. So the copy of the report is also served upon the Learned Council for the petitioner. After going through the report submitted by the Commissioner of Police, Siliguri Police Commissionerate, the petitioner submitted, he is satisfied with the report submitted by the police, as the grievances of the petitioner have been taken care of by the police authority, and the minors have been recovered, and he will take appropriate steps for taking the custody of the minor from the appropriate court of law. in view of the submission made by the full stop. The report submitted by the Commissioner of Police dated 23rd May 2024 may be kept with the recorder. In view of the submission made by the counsel for the petitioner and considering the report dated 23rd May 2024, this court find that no purpose should be served by keeping the writ petition pending. Accordingly, WPA 1052 of 2024 thus disposed of.
Grateful.
Grateful, my lord.
Next.
Number 8.
My lord, I appear for the writ petitioner.
I'm for the response.
Lord,
Yes.
kindly recollects, the petitioner is the lady constable with the relief protection force. Now we are
Yes,
aggrieved by the.
any
transfer order.
instruction?
The DSD will appear on virtual.
Yes, Mr. Majumdar?
Lordship, am I audible, my lord?
Yes, yes.
Lordship, I could not obtain any written instructions, but what
Yes.
I could gather was the department wanted to contact with the petitioner over telephone.
Okay.
She could not be contacted. To my understanding, her pair has been acceded to. But my lord, what I would suggest, being very fair to all, that my lord, let this petition be kept pending. Any actions to be taken by the department will obviously be subject to the outcome of the writ. Let the petitioner try to establish contact with her employer. I think the matter will be resolved then and there.
I will record your submission. I will record your submission and I will direct the petitioner to meet with the authority.
Lordship,
And
in that
in the
case, my lord, kindly record that I have been submitting on oral instructions, not
Correct,
on
correct,
written
correct,
writ.
correct.
My lord, if her problem is resolved, I don't want to stand in the way.
Correct.
So, my lord, subject to correction, my lord, what I have understood is that my prayer has more or less been exceeded.
That's why.
So, my lord will be recording that, the learned DSG's submission.
Hmm.
Very well. And my lord will kindly keep this writ petition
I am
pending.
keeping the writ petition pending.
Lordship.
So and so petitioner.
Lordship, Mr. Bhattacharya was very keen on obtaining a stay last date. Is he still keen on obtaining the stay?
No, he's not. No, he's telling that you have stated. That's why he's not pressing. Let the writ. No. Now the volume has come down.
No, my lord, what happened would, my lord, I be very fair. If your lordship grants a stay, even this proceeding will be stayed.
That's why on the last occasion he not passed. I know the authorities.
My lord, not better than me.
So, last time we were pressing for stay because
No,
the
that's
learned
why
DSG was
DSG
not keen to
stated-
have his
See,
submissions recorded.
I know the authorities.
Yes, my lord.
That's why you're not passed on order.
Yes, I'm grateful to you.
And so and so appearing for the petitioner. Learned DSD is appearing for the respondent authorities. Full stop. The petitioner has filed the present application praying for a stay of the impugn order of transfer of the petitioner. Full stop. The learned DSD submitted he has received an oral instruction as he could not able to get the written instruction and submit that the grievance of the petitioner is under consideration and the petitioners and the authorities intending to give personal hearing to the petitioner, but the petitioner could not be contacted. And as such, he prays for the writ petition may be kept pending. In the meantime, the respondent authorities will take appropriate decision with regard to the representation filed by the petitioner with regard to her transfer. In view of the above, in view of the submission made by learned DSG, the writ petition is and the hearing of the writ petition is adjourned till the next circuit bench. Full stop. The petitioner is directed to
Meet the
to
officer.
meet and to appear before the concerned authority for her grievances, if grievances, and to appear before this court before the next circuit.
Grateful, my lord. Grateful, lordship.
Item number 9.
I am led by Miss Mandla. She's on the virtual mode, Lordship.
Lordship, in item number 9, Mr. Aniruddha Biswas, he will appear. Let them start. Lordship, in the meantime, he will come. Lordship, he is the division bench.
Yes. Yes, madam.
Your lordship, is aware of the matter, the first charge
Madam,
sheet.
yes, I am aware, but the only question is what the SLP you have filed before the Honorable Supreme Court?
Only for bail,
No, not the bail, because kindly come to your page.
Please, I'm on interim bail, right at the moment.
No,
Before this,
that's correct, but whether this court can now pass any order, kindly come to the page in 88,
please,
page 88.
Yes,
Main issue requires detailed consideration. However, in the instant cases, since the petitions have been undergone custody for quite some time, and the main issue is to be resolved.
Only for
without-
bail,
Yes?
Only for bail,
No. This is with regard to the bail, correct?
Yes,
Then you have been released on bail. Now the second paragraph. Then second paragraph, the underlined portion, 1, 2, 3, 4, 5, sixth line.
Please,
Special criminal case number 3850/2020. This is your SLP?
Yes,
Correct. It is brought to a notice that the issue with arises consideration in this petitions have been referred to the larger bench. Once the matter has been referred to the larger bench, how this court can pass an order of this state?
I'll explain, what had happened is that I had moved my bail application before this honorable court, last year. And at that time, this honorable court was of the opinion that charge sheet without FSL is not an incomplete charge sheet.
Correct.
That time the supplementary had not come in, So they rejected my bail application.
Correct.
I went to the Supreme Court only on the limited ground that I am entitled to default bail under 167(2), given that the charge sheet has been filed without CFSL and hence it is an incomplete charge sheet. So right of default bail accrues. So that is the question, that is pending before the Supreme Court. There is a batch of 25 matters that has been long pending since
So if
It's
that be
quashing
so,
of the FIR,
so if that be so, if you're telling that you have challenged before the Honorable Supreme Court with regard to non-filing of the charge sheet within the prescribed time, you are entitled to get the bail.
Yes,
That is the matter of before the Supreme Court. So that is connected. If the Supreme Court is held that no, you're not entitled to get the bail or you're entitled to get the bail, whether that equivalent to the quashing. If the Supreme Court will say no, you're not entitled to get the bail, so how you can say you are entitled to quash get the order for quashing of the FIR?
Whereas I am led by authorities in this one. So what has happened is that various high courts, including the Honorable High Court of Bombay, High Court of Punjab and Haryana, they have held that charge sheet without CFSL is incomplete to an extent that cognizance cannot be taken of that charge sheet.
Correct.
Not only have they taken cognizance, but they have also framed charges and they're leading the evidence in the trial. The next date before the Honorable Learned Trial Court is 8th of July, So, because this question, if your lordship sees, your lordship is right in picking out that order, this is of the 12th of July 2023. No hearing has taken place, ever since then, because this is a larger bench issue. Since 21, these matters are pending in some other cases. So this hearing has not taken place. But in the meanwhile, this is only on a limited question whether bail can be granted or not. Under 167(2). We are being led by the authorities, the case compilation which I had passed over, on the last occasion. It's to say that, when the charge sheet is incomplete,
Just a minute. Hare. सुनिएगा बात मैडम के पास Yes, continue, madam.
Please, your lordship has the compilation,
Yes.
The first judgment is of this honorable court in Rakesh Shah versus State of West Bengal.
Yes.
Though I'll fairly submit it is on bail, but your lordship, the entire procedure of how, when within 180 days, if the investigation cannot be completed, then a special report has to be filed by the public prosecutor to take an extension beyond 180 days. But there is no, as per 36A4 of the NDPS Act, there is no provision to extend the period of investigation beyond the period of 1 year, my lords.
Correct.
Lordship, I'll just take your lordship to the first judgment in Rakesha, which is that page number 1 of the judgment. My
That
lords.
is with regard to the bail.
My lords, but it prescribes the procedure which ought to
Correct.
have been followed.
Correct.
Which, my lords, they have
Part
not.
of the bench. My lord was part of the bench.
No, that's why I'm telling, madam. See, this is with regard to now on the basis, whatever the judgment, I have gone through the judgment because I got some time to go through the judgment which are relied upon. This is all with regard to the bail. That is, there is no dispute on that. Now you are asking with regard to the quashing of the FIR for not filing the supplementary charge sheet within the year. That question is to be decided, and the Supreme Court is in session of the matter. How this?
No, my lords. No, my lords.
Enter
Your
into that?
lordship, Supreme Court is only deciding whether default bail can be granted or not. And for that reason, I have interim bail at the moment because the larger question is pending. So even my SLP is pending with that, only on interim bail.
Correct.
The two questions which arise before your lordship today are, first is that, my lords, whether the charge sheet which is filed without CFSL,
Correct.
which is filed within the period of 1 year, but it is without CFSL, whether, my lords, cognizance could be taken on that. The second question, my lords, is whether CFSL report can be filed by the way of a supplementary charge sheet.
Correct.
My lords, supplementary charge sheet, as CRPC holds under 173 subclause 8,
Correct.
it is only when it pertains to any novel or fresh evidence that comes in, which was not there at the time of filing of the charge sheet.
Correct.
Admittedly, in an NDPS case, the contraband is the very fulcrum and the basis of the case, which is available with the prosecuting agency from the day of the arrest. So, my lords, as per the Supreme Court guidelines in Vinay Verma's judgment, which is also, my lords, annexed in this compilation, it says that, my lords, only when there is new, novel, fresh evidence can there be a supplementary charge sheet.
Correct.
Now, what they have done in this particular case is that, my lords, within 180 days, which is 36A4, the investigation had to be completed. They did not file the charge sheet within 180 days. They sought an extension. They sought, in fact, my lords, 3 extensions beyond that. Your lordship, my lords, with the 3-judge bench of this honorable court led by Justice Joymala Bagchi in Subhash Yadav versus State of West Bengal, clearly held, my lords, that extension cannot be taken merely on the ground of non-availability of CFSL.
Correct.
But in my case, they do it. So that's why, my lords, I had taken it to the Supreme Court to say that I was entitled to default bail on that ground. Now, my lords, what they do, within 180 days, they don't file the charge sheet with the CFSL. They take 3 extensions, and after those 3 extensions also, my lords, they file a charge sheet without CFSL. So, my lords, now the outer limit period of 365 days is also over. And as per provision to section 36A4, it says that no more than 180 days beyond the initial 180 days can be given. So there is no provision of now seeking an extension. So, my lords, what they do, when they file that incomplete charge sheet without CFSL, they don't inform the court or seek any permission to place a CFSL report on record. The court also mechanically takes cognizance in an NDPS case without seeing the contraband is matching or not, which is the very fulcrum of holding me in custody is contraband. That report is not there, mechanical cognizance is taken. Thereafter, my lords, the mandate of 1 year gets over, and then a supplementary charge sheet is filed. This is not by the way of additional documents or by the way of a special permission. Supplementary is taken and mechanically cognizance is taken on the second one also, my lords.
Correct.
So, my lords, my question in this is that the first charge sheet is defective because it was without CFSL. I have some judgments which I put in the compilation to lead that, my lords. That, my lords, when in an NDPS case, the very basis is the contraband. So without CFSL report, how can one must move without a CFSL report in an NDPS case? And, my lords, the second question, my lords, which I put to your lordship is that, my lords, whether by the way of a CFSL report, something can, by the way of a supplementary charge sheet, the CFSL report can be filed, given it cannot be deemed as novel or fresh evidence, because, my lords, your lordship, the 3-judge bench of this honorable court had held that way back in 2016, there were directions by the Honorable Supreme Court in Union of India versus Mohanlal to increase the number of labs. Now, if there are not enough number of labs, my lords, can, my lords, that your lordship, this honorable court held to be an institutional failure. It is not something that the accused must suffer. And then, my lords, mechanically taking cognizance of incomplete charge sheets. Because, my lords, we have also seen while handling appeals arising out of my lords, West Bengal, that it has happened that sometimes, my lords, CFSL reports are coming in when evidence is led and almost at the end of the trial also. And
Correct.
sometimes, my lords, they don't place it in the charge sheet and they keep it in the case diary.
Correct.
So how does one authenticate that in an NDPS case that you're going ahead on basis of some contraband and that report to verify that very contraband is not on record, Millers? So in that perspective, Millers, I just like to take your lordship through two judgments, and then Millers, I'll leave it to your lordship. Because well, this is in no way overlapping what is before the Supreme Court. That's only a limited point on whether I was entitled to default bail, given that they didn't file the CFSL report with the charge sheet at that time. An extension merely on the ground of non-availability of CFSL is held to be impermissible by your lordship's three-judge bench judgment, Millers. So, Millers, in Rakesh, sir, in that perspective, I'd like to take your lordship through this judgment. Lordship, the page 1, para 3.
Yes.
Can I be permitted to read minutes?
Yes.
Minutes. The primary contention urged on behalf of the petitioner through learned counsel is on section 36A4 of the NDPS Act read with the proviso. Counsel submits that the IU submitted charge sheet on so-and-so without CFSL report. Counsel submits that the learned trial court mechanically took cognizance of the submission of the charge sheet by order dated so-and-so. Counsel relies on a line in the charge sheet stating that a supplementary will be submitted after receiving of the examination report to submit that is contrary to proviso of 36A4 of the NDPS Act. Learned counsel for prosecution submits that the charge sheet dated so-and-so contains a prayer of the IO for filing of supplementary charge sheet upon obtaining report of the drug control laboratory, and hence there is no requirement of obtaining any permission from learned court for conducting further investigation in terms of 173(8) of CRPC. Section 36A4, para 5 of the NDPS Act relates to offences triable by special courts. Section 36A4 is pari materia to 167(2) of CRPC and requires investigation to be completed within a stipulated period of 180 days. The only difference is that at the time frame of 90 days under 167(2) of CRPC is to be read and construed as 180 days in respect of offences punishable under specific provisions of the NDPS Act as provided under 36A4 or for offences involving commercial quantity. The proviso to 36A4 is relevant for the cases as is set out here under.
Yes.
Yes, Millets. So, Millets, in 36A4, it says 90 shall be replaced by 180, and the proviso says, Millets, provided that if it's not possible to complete the investigation within the set period of 180 days, the special court may extend the set period up to 1 year on the report of PP indicating the progress of the investigation and the specific reasons for detention of the accused beyond the set period of 180 days. It would be evident from the above that the proviso clearly indicates that in the event the investigation not being completed within 180 days, the special court may extend the period beyond 180 days, but up to a maximum period of 1 year. On the requirement of the public prosecutor indicating progress of the investigation on specific reasons for detention of the accused beyond the period of 180 days. The points 1, 2, 3 are not disjunctive and should be read in continuity. A plain reading of the proviso to 36A4 indicates that the special court is required to consider point 2 and 3, apply its mind, and pass a judicial order on the report of the public prosecutor on what has been brought before the court. The order of the special court must reflect the basis for allowing or rejecting the prayer of extension of time beyond 180 days for completing investigation. The case of the prosecution rests on the line contained in the charge sheet submitted on so-and-so, stating that a supplementary charge sheet will be submitted after receiving of the chemical examination report from the Office of the Director of State Drugs Control Research and Laboratory. This, in our view, is not an answer to the specific mandate of the proviso to section 36A4 of the NDPS Act. A mere statement of filing a supplementary charge sheet upon obtaining the examination report does not conform to the statutory mandate under proviso 36A4 of the Act. The rigors of proviso 36A4 of the NDPS Act was held to be a condition precedent for extension of period of detention by a special bench in Subhash Yadav versus State of West Bengal in so and so. In that decision, the special bench also took judicial notice of the systematic reasons for the failure to obtain reports from central and state forensic laboratories and fundamental right of the accused to a speedy investigation. Subhash Yadav proceeds to hold that the steps required to obtain analysis report does not require continued detention of an accused. The reliance of the prosecution on section 173(8) of the CRPC is also not tenable for the following reason. Section 173(8) of CRPC permits further investigation in respect of an offence after a report under 173(2) has been forwarded by the officer in charge of the police station to a magistrate empowered to take cognizance of the offence if the officer in charge of the police station obtains further evidence. The petitioner before us, on the other hand, has been charged for commission of an offence under the NDPS Act, which requires the trial court to take cognizance of the offence committed under the Act. This means that the CFSL laboratory report becomes an essential and integral part of the investigation for establishing the charges under the NDPS Act. The chemical examination report therefore becomes the most vital piece of evidence which is required to be made a part of the charge sheet. Moreover, there is a fundamental difference between expression of further investigation under 173(8) of CRPC, where the presumption is of new evidence, and the laboratory report in an NDPS case, where the report forms the fulcrum of the charge sheet on which the trial court is to take cognizance of the offence. In Sagar Purushottam Joshi versus State of Maharashtra, a single bench of Bombay High Court held that the magistrate cannot form an opinion and take cognizance of commission of the offence under the NDPS Act without the chemical analysis report. So, Millets, thereafter, this has been held, Millets, that the fact that the charge sheet, Millets, then this is on the facts of the case thereafter, and bail was granted. But what emerges from this is that, Millets, in terms of section 36A, extension has to be sought. Extension cannot be sought in terms of merely non-availability of CFSL report, which is in our case. Thereafter, my lords, once the charge sheet is submitted, if it's without a CFSL report, even cognizance cannot be taken mechanically because the CFSL report forms the very fulcrum of the case. In this charge sheet, my lords, I'll take your lordship to the charge sheet also, in which similarly, same line is there that CFSL will be filed in supplementary charge sheet, which has been distinguished, my lords, that supplementary is only for new evidence and not for evidence that you've had. So in that case, my lords, the first charge sheet is incomplete for being without a CFSL report, my lords, and the second charge sheet cannot be accepted as a supplementary charge sheet because it does not meet the rigors of 173 subclause 8, since there is no novel or further evidence that has come in. So to that, my lords, to substantiate that, I'll take your lordship to the next judgment. Millets, this is an opinion. Now, Millets,
when the court has taken the cognizance on your case, madam?
please, Millets. Millets, the cognizance has been taken on the same day as the first charge sheet was filed. I'll just take your lordship to that exact page also. Millets, charge sheet was submitted on the 25th of November.
25th November 2022.
Cognizance is taken on the same day. Your lordship may have the order at page number 72, Millets. Millets, first, your lordship may just have 71 for a moment to show that how they have dealt with the CFSL report in this.
Yes.
71, Millets, the last paragraph.
Supplementary charge sheet will be submitted after collecting chemical examination.
Yes, Millets. And then, Millets, same day, Millets, cognizance is taken at page number 72 without Millets making any note of the fact that the CFSL is not there, mechanically taken cognizance. And does not even say that, Millets, the PP or the IO is seeking more time or time is granted. Because, Millets, supplementary cannot be filed. That I'll establish, Millets, by the way of Supreme Court judgments in this, Millets. So then, my lords, this is so far as the first charge sheet without CFSL is concerned. Then, my lords, they come with the second charge sheet, which is, my lords, at page number 74. This is the supplementary charge sheet, my lords,
Page?
74, my lords.
Yes.
Your lordship may see from on the left hand side, 4 lines from the top, it says supplementary charge sheet. Final report, charge sheet, untraced, unoccurred, and there it says supplementary charge sheet. On the left hand side, my lords.
Yes.
Thereafter, my lords, page number 76 is relevant for your lordships.
This was filed on?
My lords, this was filed on 4th of January 2023. And my period of 1 year expired on 11th of December 2023, my lords. 2022, my lords. Sorry.
When your the 1 year passed, 11/12/2022.
Please, my lords, because my lords, I was arrested on 11/12/2021. No.
Yes.
Please, my lords. My lords, 76 is then relevant in that regard.
76.
Please, my lords, 76, my lords, page number 76.
Yes. During further investigation.
Yes, my lords. This says it's further investigation, my lords. We can't account for further investigation, my lords.
Yes.
So, my lords, with that, they filed the charge sheet, my lords, supplementary charge sheet, and then your lordship may see that now charges have been framed. The charge framing order, my lords, is at page number 79.
Page 79.
Please, my lords.
This is the cognizance, second cognizance.
No, my lords, this is the charge sheet. Also, charge framing order, my lords.
Charge frame. No, whether after the receipt of the supplementary charge sheet, another cognizance was taken on that
Yes, my
supplementary
lords.
charge.
Cognizance was taken, my lords. The second cognizance order is at page number 73, my lords.
73.
Yes, my lords. Your lordship has 73.
Yes.
Well, as it says 4th of January 2023, one supplementary charge sheet filed today on behalf of SI so-and-so, cognizance taken. And then, Millets, it just says that matter is list for framing of charge at the bottom, Millets.
Cognizance is taken. Where it is? Today the fixed for supplementary charge sheet filed so and so.
Millets, cognizance taken is the second line. If your lordship may see one supplementary charge sheet
Yes.
filed today, then
Yes.
the next line is
Cognizance.
cognizance taken.
Correct.
So, Millets, mechanically cognizance taken on the second charge sheet also.
Correct.
And thereafter, your lordship has seen, Millets, the charge framing order. So charges are framed, my lords, on page number 79 with the order dated 26th of April 2023. So the first charge sheet, my lords, defective for not having a CFSL report. Second charge sheet filed as a supplementary, cognizance taken mechanically, and both in charges framed, my lords.
Twenty-one C and 25.
Yes, my lords. My 21C is, my lords, commercial quantity. 25, my lords, is it's a one of the sections, my lords, for just transporting my lords, contrabands, my lords.
Correct. Next.
So, my lords, the
Now the case is at the stage of evidence.
evidence, my lords. It's listed for evidence on the 8th of July 2024, my lords. My lords, the thing is, my lords,
Any witness have been examined?
no, my lords, because witnesses are not showing up, my lords.
Not started.
No, my lords.
Yes.
Evidence stage for my.
My lords, there are 2 more judgments before I conclude, my lords.
Which judgment?
Please, my lords. Malas at page 6, Malas, is a similar opinion by the High Court of Punjab and Haryana on Millet's charge sheet without CFSL being an incomplete charge sheet and that cognizance cannot be taken, Millets.
Where
I'll
it,
just-
which,
Lordship,
which
Millets,
paragraph you are relying upon?
please, Millets, I'll just take your Lordship to only the relevant page. Your Lordship may see page number 22. One of the question in this was, they said that when we can see the contraband with our naked eye, why a CFSL report is required? And even if you
Page
sample
20,
for
22.
please, Millets, 22 of the compilation minutes.
Yes, which paragraph?
Millets, the second paragraph. From there, Millets, just 3 paragraphs I'd like to read. With respect to the question posed by the learned single judge regarding some of the contraband being identifiable through naked eye inspection based on experience and knowledge would be a great fallacy, and we would respectfully state that it would be grossly unsafe to rely upon an opinion based on a naked eye inspection backed by experience or knowledge to arrive at prima facie opinion of commission of an offense to submit an accused to rigors of trial by magistrate in exercise of its power under 190 CRPC. The only way it can be done through is establish the nature of contraband on the basis of chemical examiner's report. And for this reason, the chemical examiner's report assumes an immense significance for the trial to formulate an opinion, as the very cognizance of the offense would depend on it. Non-inclusion of the chemical examiner's opinion in the report under section 173 would expose the accused to unfounded dangers, imperiling and endangering his liberty, since the provisions of NDPS Act in its applicability to a trial and conclusion are stringent in consequence. For this reason as well, it is essential that the report of the chemical examination report be included in the report under 173, and without which it can be best termed to be an incomplete challan, depriving the magistrate of relevant materials to take cognizance. And if it is not submitted with the requisite period of 180 days, it would essentially result in default benefit to the accused unless an application moved by the investigation agency apprised to the court of the status of investigation with a prayer of extension of time to the satisfaction of the court. We emphasize that the stringent aspect of NDPS Act, which would compellingly persuade us to take the aforesaid view without determining the nature and content of the contraband, it would be draconian to propel an accused into the throes of a trial. The liberty of an individual would be constantly be imperiled at the hands of dubious officials of the police who may venture to falsely implicate a person. It is for this reason we would unhesitantly conclude that the chemical examiner's report is an essential, integral, and inherent part of the investigation under NDPS Act, as it would lay the foundation of an accused culpability without which a magistrate would not be enabled to form an opinion and take cognizance of an accused's involvement in the commission of the offense under the Act. So, Manas, this is one judgment on similar lines.
That is correct. That is correct. But where you can say that, okay, next.
Please, Manas. Manas, then similarly, Sagar Purushottam, Manas, there was a brief quotation of Sagar Purushottam's judgment of Bombay High Court in Abdul Rakib. Your Lordship may not necessarily need to read that again, because it also has similar overlaps to say that cognizance cannot be taken. Then, Millets, your Lordship is aware of the judgment of this Honorable Court in Subhash Yadav, Millets. In Subhash Yadav, Millets, is at page 39, just 2 paragraphs in there, Millets. 39, the judgment starts. Para 22 is the relevant. 22 to 25 is relevant, Millets.
But the last page 23, which you have relied upon the Punjab and Haryana High Court.
Millets.
Page 23.
Please, Millets.
Kindly come to the paragraph 3.
Please, Millets.
We are the conscious. Got it? Can
Yes.
you read
Yes.
paragraph 3 of page 23?
We are conscious of the fact that these issues have been largely on account of inability of the state to provide chemical examiners report in time, ostensibly for the reason that it is not equipped with enough laboratories to examine the contraband. But for that, it is the state which has to be faulted, and it would do well to hone up its own infrastructure so that the accused who deserves punishment does not get benefit of law and go scot-free and gain access to an undeserving liberty. This
Correct.
should also sensitize the investigating officers to make an application or for extension of time to submit the report in its prescribed period so as to obviate any chances of the accused getting benefit of the default clause.
Yes.
We therefore answer the reference as above, list all
Correct.
cases before the single bench.
Correct. So, so the court has held that you cannot be scot-free if on the fault of the state.
Please, minutes.
Yes, next.
Thereafter, minutes, there is your lordship's minutes 3-judge bench judgment in Subhash Yadav minutes.
Subhas also, that is the same.
Your lordship is aware.
Which paragraph you are relying upon?
Minutes para 22 through 25 minutes.
This is an extension, Lordship. Listen, I was there, and my name is not recorded, but I was there. My Lord, yes, we appeared online, I remember. You also went to Calcutta.
Yes, next.
Please, minutes. After that, minutes, the next judgment is of Vinay Tyagi. This is at page 55. This is to say, minutes, that supplementary cannot be filed when there is no fresh or novel evidence. And for that reason, minutes, it's my respectful submission that the CFSL report cannot be filed as a supplementary charge sheet. Because, minutes, it takes away the very rigors and mandate of the statute, which says beyond 1 year, you cannot file, you have to complete the investigation within a period of a year.
Okay.
And don't do it, supplementary should not be the way. Minutes, just 2 paragraphs in here, and then I'll conclude. Your lordship may please have page 75, para 21.
Para 20.
21 minutes, page 75.
Yes.
Your lordship has that?
Yes.
The initial investigation is one which the empowered police officer, which the empowered police officer shall conduct in furtherance of registration of FIR. Such investigation itself can lead to filing of a report, final report under 173 subclause 2 of the code, and shall take within its ambit the investigation which the empowered officer shall conduct in furtherance of an order for investigation passed by the court of competent jurisdiction in terms of 156(3) of the code. Further investigation is where the investigating officer obtains further oral or documentary evidence after final report has been filed before the court in terms of 173(8). This power vested with the executive. It is in continuation of previous investigation and therefore is understood and described as further investigation. The scope of such investigation is restricted to the discovery of further oral and documentary evidence. Its purpose is to bring the true facts before the court, even if they are discovered at a subsequent stage to the primary investigation. It is commonly described as supplementary report. Supplementary report would be correct expression, as the subsequent investigation is meant and intended to supplement the primary investigation conducted by the empowered police officer. Another significant feature of further investigation is that it does not have the effect of wiping out directly or impliedly the initial investigation conducted by the investigating agency. This is a kind of continuation of previous investigation. The basis is discovery of fresh evidence and continuation of the same offense and chain of circumstances related to the same occurrence incidental thereto. In other words, it has to be understood in complete contradiction to reinvestigation, fresh or de novo investigation. However, in the case of fresh and reinvestigation, this is not precisely relevant for your lordship at the moment.
Yes.
Thereafter, minutes. One judgment of the Delhi High Court in Surendra versus State of NCT starting at page 91. In this, minutes, applying the principles in Vinay Tyagi, there was a supplementary charge sheet which was filed, which was based on the evidence which was already there at the time of minutes, the initial investigation. So, minutes, page 96, para 12 onwards. page 96, para 12 minutes.
But in this, kindly come to the last paragraph. In this case,
Please minutes.
the conclusion parts.
Minutes for minutes Surendra or Vinay Tyagi minutes.
This last one,
Please minutes.
page 125, conclusion.
Yes, minutes. Yes, minutes.
Keeping in view of the above mentioned principle and the law under the CRPC, this court finds the supplementary charge sheet filed subsequent stage after the alleged further investigation was not filed after having been found any fresh material or evidence. And therefore, neither was a further investigation proper and in accordance with the law, nor the supplementary charge sheet is sustainable in the eye of law. The materials relied upon the investigating officer at the time of filing of the subsequent charge sheet, supplementary charge sheet was present at the time of filing of the first charge sheet. As well, in the first charge sheet, the petitioner was put in the column 12. So he was there and there is a material was there. That the question of filing the supplementary charge sheet does not arise and the case has not been proved. That,
Yes, minutes.
then kindly comes to page 43. The supplementary charge sheet is set aside.
Yes,
So-
minutes. It is set aside.
No. So there was no, there was
Here and there also minutes, what happens is, because this is from a larger frame that we also see, given that there's an increased number of the default bails under 36A4 also. Because your lordship may put in some directions if your lordship does not even deem it necessary to quash the present FIR, for the fact that, my lords, there is a reason for which, my lords, 36A4 has been put in there. Initial investigation within 180 days. Then your lordship says that merely on account of non-filing of CFSL report, one cannot take benefit of holding, just curtailing the right of the accused person.
correct.
So your lordship may see that what happens, Milos, in a lot of trials, realistically is that because, Milos, this question has not been determined, whether a supplementary charge sheet can truly be ever considered as fresh or novel evidence. So that, my lords, when well within the trial, we have seen, my lords, that the CFSL report comes at a belated stage. So as a result, my lords, it is different in cases which is simple as ganja. Because in ganja also, there is some distinction where they say the flowering drops of ganja, in some courts they say that is with contraband under the NDPS Act. Some courts have a different opinion to it. But Miller's NDPS Act also has solubles and mixtures. So Miller's the determination for those whether they even come within the NDPS Act cannot be done without a CFSL report.
Okay.
Miller's for in those rigors, that is Miller's for those precise reasons that these section 36A4 was put in along with the proviso to put in a time limit so that the right of speedy trial of an accused is also taken care of, that the investigation is completed, so the trial actually proceeds as well. But Millards, if the charge sheet is incomplete, Millards, on what account the trial is going ahead, Millards, charges are being framed mechanically without so much so as a noting, Millards, anywhere in the cognizance order that today I'm taking cognizance without the CFSL report being on record. So what is the prima facie evidence that is available, Millards, then in that regard? That is my limited submission to your lordship.
Okay.
That when Millards, a recording says that prima facie there is consideration. Millards, without a report, Millards, how is there a prima facie consideration, Millards?
Okay. Yes.
My lord, I'll be very precise. So what I understood from the entire argument, there are 3 points. One, whether the charge sheet, the first charge sheet filed in terms of section 173, subsection 2,
First charge sheet, no
is
dispute.
complete or incomplete.
First charge sheet is not dispute.
Lordship,
It is filed
lordship.
within the extended period of 180 days.
One, not
The only
thereafter, the
question here,
supplementary charge
only
sheet,
question with regard to the supplementary charge sheet we have filed, that is also after the period of 1 year.
1 year. Now,
Correct. Whether on that charge sheet, the court can take the cognizance. This is the only question.
This is the
If
only
the court cannot take the cognizance, the trial cannot be held.
lordship,
Because you cannot, by the naked eye, the investigating officer cannot say this is the coding having so and so.
yes.
So you have to prove from the materials available on record. Yes, this is the coding having so and so quantity of the narcotics,
Lordship.
and this was found in the possession of the accused. So if the supplementary charge sheet is not taken into consideration, admittedly the supplementary charge sheet is filed after the period of 365 days. 1 year, not the
Lordship.
there has not been 1 year.
1 year.
After the period of 1 year, whether on the basis of that charge sheet, the cognizance taken by the special judge
Is valid
is
or not?
right on.
Lordship.
And you can proceed, the prosecution can proceed with the trial of.
Lordship.
That
The
is the
case,
simple-
first of all, the case is in the evidence statement. Lordship, the outer limit of what she stated, the outer limit of completion of investigation is 1 year maximum.
Maximum.
Lordship. This is limited to the submission of first charge sheet in terms of section 173 subsection 2. Subsequently, the further investigation is not confined with that proviso, Lordship, within that proviso. Further investigation is something that is.
So that's why the
that
further
is-
investigation is something. Where is the extension? Where is the extension after 130?
After 1
1
year,
year.
there is no extension necessary,
Then
Lordship. Nothing
after-
necessary.
So after the 1 year, there is no extension. Though in the first charge sheet, you have stated that the supplementary charge sheet would be filed after getting the CFSL report.
Lordship.
And 11th December 2022, your 1 year is completed.
Yes.
Correct.
Yes.
1 year is completed. Where is your extension from the court?
Lordship.
How you can justify 36 capital A?
Yes, Lordship, 36 capital A is limited to the filing of charge sheet in terms of section, subsection 2.
Show me the supplementary charge sheet and the main charge sheet are differentiate in 36. Show me.
Lordship, the outer limit of 1 year, this is for submission of charge sheet. Not the supplementary charge sheet is Lordship, the section 170 subsection 8 of the CR.
If that is so, if that is so, you're telling that, then what about the order passed by the coordinate bench of this court? In the case of
Yes.
the first order, in the case of Rakesh Shah?
Yes, Lordship, there is a judgment, Lordship, but Lordship, in my opinion, Lordship, it kindly come to subsection 8 of the CR 170 subsection 8, Lordship.
CRPC?
CRPC, Lordship. The further investigation is based on this provision only, Lordship. May I read, Lordship?
Yes.
Nothing in this section shall be deemed to preclude further investigation in respect of an offence after a report under subsection 2 has been forwarded to the magistrate and where, upon such investigation, the officer in charge of the police station obtains further evidence, oral or documented. He shall forward to the magistrate a further report or reports regarding such evidence in the form prescribed, and provisions of subsection 2 to 6 shall, as far as may be, apply in relation to such report or reports as they apply in relation to the report forwarded under subsection 2. Lordship, now, further investigation, there is no time limit prescribed for further investigation. Further investigation, whenever there is a new discovery. It is a new discovery because at the time of submission of first charge sheet, Lordship, the IO was aware that this might not, that it was ascertained. The new discovery was done during the further investigation after the FSL report was received. This is a new documentary evidence, Lordship. Therefore, there is no bar to forward with a supplementary charge sheet. There is no time frame prescribed for an investigation. And in the case of Bhinubhai Horibhai Malov, reported in 2019 volume 1 volume 17 page 1, Lordship, SCC. In this judgment at paragraph number 42, it has been decided by the Honorable Supreme Court that supplementary charge sheet can be filed up to the stage of framing of charge, and there is a subsequent judgment even after framing of charge can be filed, Lordship. Therefore, the intention behind the provision is that the entire investigating agency is to be given an opportunity to bring the entire material before the court for proper adjudication.
But even 167 read with 173, whether there in the 167 there is any stop with regard to the investigation of the certain period?
No, Lordship.
No.
Is equal to the bail only.
It is related to bail only.
Bail only. Correct. So that's why I'm asking. That's why I'm asking the question. So if it is on with regard to the bail, what about the trial? That's why I'm asking, because they are telling if once for the one purpose For the one purpose, you are telling that the filing of the charge sheet after the period, extension period, the petitioner is entitled to get the bail. So what would be the effect with regard to the trial?
Trial will not be hampered because.
That's why I'm telling, satisfy this court. Why? How? Why? Why there are two distinctions? Why there are two distinctions? That's why the petitioner has made out a case. If the court, already courts have held, this court, our court, Bombay court, and held that once you file the supplementary charge sheet, that is the out of the limited period and time prescribed, the charge sheet and you cannot take the cognizance. If you cannot take the cognizance, how the trial can proceed?
Report number one is. One, তুই মামলা করে দেখছি আমি দেখছি টাইম ফ্রেমটা কি সেটা বল as soon as the investigation is
Lordship, the period of investigation, it is an offense of commercial quantity of contraband, Lordship. The punishment may extend to 20 years, Lordship. Therefore, I am entitled to have 3 years for a completion of investigation as per 468 CRPC, 467 CRPC, Lordship. The period of investigation, completion of investigation is 3 years, the maximum limit. There is no limit. There is no limit.
How you can connect with the NDPS?
Lordship, this is the general provision, section 50.
Kindly show,
Section 50.
kindly show me how you connect with that.
I connect.
That is correct. You are submitting. Otherwise, all the 3-0 case, the matter will go out.
Yes.
But with regard to, so what was the purpose of 167?
Yes, Lordship. Coming to 51 of the NDPS Act.
Yes.
The provision of the Code of Criminal Procedure 1973 shall apply insofar as they are not inconsistent with the provision of this Act to all warrants issued and arrest, seizure, search made under this Act. Lordship, this is a provision. This is not inconsistent with the any specific provision of NDPS.
Can the seizure can.
Therefore, this is the.
Kindly read 51.
Lordship. Insofar as they are not inconsistent with the provisions of this Act.
Correct.
To all warrants issued, arrest, search, seizure made under this Act.
Correct. So they are not challenge your seizure.
No. Seizure is not
Such
the
is
issue.
not
Lordship.
challenge. Such is not challenge. They have challenge with regard to the filing of the charge sheet after the supplementary charge sheet after the 1 year. Can we check the trial? Can
Lordship,
we check?
Lordship, I'll be requiring some time for this, but answering this issue. Lordship.
For the last 3 days, you are taking time. The third day.
This particular point.
And
it
third day,
appears today.
because the counsel for the petition argued the matter on the very first day. I have taken note of it, but in your presence, I again heard how.
Lordship,
First day you
give
have,
us
first day you have
2 days
taken time,
accommodation,
second
Lordship.
day you have taken time, now third day.
Matter may be taken online, will be appearing online and satisfy one
No,
part.
I am not interested even online, but you should, then I am putting the cost upon you, adjourning the matter. Waste of about 1.5 hours.
Miller's may
11 to 12:30 of.
Lordship, there is no specific, the entire investigation is to be completed. There is no such provision in the NDPS Act, that within 2 years, 3 years, there is no specific provision. Therefore, the CRPC will be applicable there.
Okay, next.
Next is, Lordship, I am relying upon a judgment of the Honorable Supreme Court. And about complete and incomplete charge sheet, Lordship, that there is a judgment of Ritu Chamaria, my lord knows, that has been stayed by the Supreme Court. Therefore, that issue is pending before the Honorable Supreme Court.
You tell me, the application which is pending before the Supreme Court, what is the point involved in that? Have you gone through that?
Incomplete charge sheet, Lordship.
Huh?
Ritu Chamaria is about incomplete.
No. This petitioner has filed this SLP before the, you persons are not reading the brief and appearing before the court. That is the problem. Have you gone through the Supreme Court order? I find in the circuit bench, none of the lawyers are reading the briefs. The court has to do the homework. Kindly come to the page 84. And come to the page 88. How he got the bail? What is the subject matter of the Supreme Court? For the last 3 days, you have taken time, how you to take instruction? Your officer has taken, notice has been issued. You had appeared. What instruction you have taken from the Supreme Court? Kindly come to page 88, the first paragraph, the bail was granted. Second paragraph, it is brought to our notice that the issue which arises consideration in petition has been referred to the larger bench. What is the point involved in that? The first question I put to the petitioner, you have not taken care of the question put by this court to the petitioner. You have not taken care of it. Sitting here, you have not read the brief.
Yes, Lordship.
Then what is the question? She is telling that the question only with regard to the after filing of the charge. If that is the point involved, if that is, if even though the cognizance has been not challenged in that, even though the petition has challenged that the charge sheet has not been, the supplementary has not been filed, how it is correlated in this application? Madam, you are having the SLP copy?
Yes, my lords. Your lordship
You're
will,
having-
I'll open it for your lordships right now.
You are having the SLP
On,
copy?
I'm not having the SLP.
So what you are doing here?
but I'll just forward it to him, your lordship.
Yes, he is-
I'll just, your lordship may see, it only arises only for bail minutes. I'll just pass it on.
If it is the bail, why the matter has been sent to the larger bench?
Melis, the larger question that the Supreme Court is dealing with is whether charge sheet without CFSL is an incomplete charge sheet or not.
That is correct. If it
Only
is
for with regard to bail, Melis. Only for
No,
bail. Supreme
Madam,
Court-
if in the bail, if the court is, it is incomplete after filing of the, then automatically the trial goes.
I bow down to your lordship, but Melis, my limited difficulty is that Melis, those matters are not being heard for the last 3 years.
What can be done? You have to file an application before the Supreme Court
No,
for
Melis.
proceeding.
No, Melis. Melis, please, I bow down to this, Melis. Melis, in an SLP, I can only impugn the limited order which has been rejected by the Honorable High Court. If your Lordship rejects my application today,
No,
I
no.
can take it to
If
Supreme
it is so, kindly that too, kindly see the page
I've
88.
sent, no, Manoj, I've sent the.
Release on interim
copy.
bail. Release on interim bail subject to condition for the purpose the petitions are produced before the trial court.
I
Then
bowed on
you
it,
brought to a notice that the issue which has been raised for consideration of the, and it is not that your first your application was filed, your application was tagged with this by the order.
Your Lordship may just please see, Manoj.
And you can to page 82.
Manoj,
Page 82, your application was tagged here in terms of that order.
I bow down, Manoj. May please allow me for a moment to answer this, Manoj.
Yes.
Manoj,
I'm asking that.
please, Manoj. Manoj, in my High Court, I just want to show your Lordship my impugned order. I've sent the entire SLP to my learned friend. In the meanwhile, I'll show from this file the High Court's rejection order.
That's how you have gone through.
Supreme Court.
I have gone through that order.
Yes, Manoj. So, Manoj, when Manoj, I filed something in Supreme Court that will only be limited for the rejection. So, my rejection was only on the point that my bail was not being granted to me. This point, this is a fresh 482 for this thing, Manoj. For the first time, a 482 has been filed. That was a bail application, Manoj. So, that bail is being decided at the moment.
Okay.
This is in the meanwhile, the trial is going on, Manoj. So,
Okay.
Manoj, if your Lordship does not interfere on any ground, Manoj, then I can, Manoj, tag this petition over there in the before the apex court.
Okay.
Now, Manoj, insofar as, Manoj, what has been raised by the prosecution, that section 468 of the CRPC gives them the power.
Yes.
Manoj, that limitation of prosecution in the sense that, Manoj, if an offense takes place, for how many years, Manoj, can it, or how many years before it runs out on limitation to even be reported to the court, Manoj? That has nothing to do with the fact that the investigation can go on for 3 years. Because, Manoj, my simplest question is, Manoj, that, Manoj, section 26A4 cannot be only strictly be read as a provision for bail. Because, Manoj, bail and trial stems from the same charge sheet, Manoj.
Correct.
Investigation will be completed in one stretch. Whether it will be for bail, whether it will be for trial. In not all cases, is the person arrested also, Manoj. So not
Yes.
in all cases that the concept default bail or for bail even arises, Manoj. So,
Yes.
Manoj, investigation, when it has to be completed within a statutory period, Manoj, that is for the trial. It is
Correct.
just so that bail is an ancillary provision there too, but one cannot put it in watertight compartments to say that, Manoj, for investigation purposes, for a charge sheet and for the trial, it will have a different outer limit period, and for bail, it will have a different outer limit period. Investigation would be deemed as investigation at the end of the day, Manoj.
Okay.
That is my respectful submission.
Okay, thank you.
Learned friend has the entire SLP's copy, soft copy has been forwarded.
I'll give a clarity. Though I am not in this matter, but he's facing some problem to assist the court. If I am permitted to make one submission, Lordship. Lordship only seeks section 36A4 of the NDPS Act.
Correct.
In respect of person accused of an offence punishable under such and such, or for a commercial quantity, reference in subsection 2 of section 167 Code of Criminal Procedure, 90 days, and that is 180 days. Now, Lordship sees the 167, if the investigation is not completed within the statutory period, is
Then proviso, can be come to the
Lordship.
proviso.
Provided that if it is not possible to complete the investigation within the said period, the 180 days may be extended to
1 year.
1 year. But, Lordship, the 167.
So
167
what is the
has-
necessity? What is the necessity to put the bracket of 1 year?
Yes, Lordship.
If you are telling that it will go to the 167.
Lordship is absolutely correct, and what has fallen from the mouth, that is the intention of the legislature was giving the extended period so that the investigation can be completed within the statutory period. But, Lordship, in spite of Mohanlal's judgment, Lordship knows the infrastructure of our country and whether we have made a delay in sending the FSL or not. We have prayed before the FSL in proper time, but it is due to the government machinery, those have been not received.
Okay.
But if on this ground, whether the charge sheet submitted without the FSL is complete or not, this is under subject which Lordship knows. So it was the submission of learned Senior Counsel Tushar Mehta. It will open the Pandora's box, because if every person will get the benefit of the same. So, Lordship,
When the trial is fixed, madam?
Millards, it's for 8th of July, Millards is the next date, Millards.
8th of July. So I am fixing on 11th, 10th itself. So for hearing of this as a specially fixed matter,
If it's
10th
possible for
10th
your
of July,
lordship
lordship.
your lordship may take this matter, my lords, with you, my lords. Your lordship has substantially heard us, my lords. On the next circuit, if we argue, it will be re-agitating the entire case, my lords. If your lordship deems it fit, your lordship may take this matter with you, my lords. Is my limited request, my lords, because your lordship has heard us substantially.
I cannot take the hearing because today is the last date of the circuit.
Let's we'll assist your lordship virtually, my lords, because my lords, this previously also, my lords, has happened in circuit matters, my lords. That my lords, because now substantially your lordship has heard the entire issue. It's not only on the limited point of stay, your lordship has heard us completely on the matter, my lords. It will be just amounting to re-agitating, my lords, and again in the next circuit, my lords.
So anything further required? Any further we argue? So I will
Your
take
lordship
the
may reserve it.
complete hearing.
Please, my
Lordship,
lords.
clearly.
So I am fixing as a CAV and I'll pass judgment
Please, my
through.
lords. Bow down, I bow down, my lords. Your lordship may reserve this, my lords.
We are submitting one judgment.
Yes, you give whatever the judgment, then I will.
I'm giving.
And Lordship, this Ritu Chapriya's judgment was stayed by Talwar's judgment, Lordship knows.
My lords, Ritu Chabri is only for ED matters, my lords. It does not apply to NDPS.
That is taken into care in this Talwar matter.
Yes,
I have given the copies to other side. There is a 5-year judgment on
The
this.
copy of the SLP kindly grants me, Lordship, half an hour time, I'm getting it printed.
You give it to my court office.
Yes,
Give it to my court office.
SLP.
SLP copy.
So
These
I have given the copy.
this all are you have given this.
3 judgments.
3 judgment.
One is a 5 judgment judgment, what is the requirement of a complete charge sheet? And there is a 24 judgments, all these issues have been clarified. The requirement of further investigation and whether it affects the trial or not. After the submission.
Sensation and suffering for the petitioner, sensation and suffering for the respondent. State. Full stop. Hearing concluded. CAV. Full stop, subparagraph. The registrar of this court is directed to send the record of this case to the principal bench to place before this court for delivery of judgment. Through virtual. Thank you. Thank you.
Deeply obliged.
Paying for not to the
Huh?
Paying for not to.
Who is for the petitioner?
Mr. Hillel Shah put the.
Huh?
Mr. Hillel Shah put the.
Yes.
Mr. Hillel Shah put the lordship.
Where is he? You have given a 1 paragraph notice for mentioning. Now today I'm telling that.
No, lordship, he's busy in court number 1, so that.
How much time it will take? And why you have mentioned this? Who has mentioned? You have mentioned.
No, I.
Who has mentioned this matter? You.
In lordship, short passover may be taken.
Yes, call. Arjun, I will not leave this matter. Call. Tell password. Password. Yes.
Item number 11, there was a direction for filing affidavit in opposition, my lord. On the filing the same.
My lord, the directions for filing were, they have to file by 30th of April, my lord.
They are not filed.
They have not filed and
This
they're seeking,
appeared for the first time now.
they are seeking extension.
I'm not seeking extension.
I mean, if you are.
My lord, and they have not
If
received
you
the
are-
copy.
Yes, I have it, served the copy.
My lord, I told him to take the copy, he refused to take.
But you filed the affidavit after the period which the court has granted.
First time it is appearing, my lord, after the direction, my lord.
What is your duty, madam? The affidavit is to be filed where?
The department.
So, how you can say that
But it
court
is
is-
appearing for the first time, my lord.
No, it is.
I have been appearing repeatedly.
Huh?
I have been appearing
No.
repeatedly. You have not seen virtual hearing, it seems.
Yes, what is the matter? You will use the reply.
My lord,
You will use the reply.
I can use in case they have anything. You are giving the reply.
I'm the private respondent, my lord.
Private-
For the private respondent, who is for the state?
The state is Union of India, my lord.
My lord, the Union
They
of
will-
India is in conflict with the appointing authority. I'll just, my lord, if my lord is prepared to hear me out,
No, whether you will you will file the affidavit in reply to this affidavit, then I will adjourn the matter. If you want, no, you will
The
not
only,
file
the only thing, my lord, in case they have brought in anything to the contrary, which is mentioned here in
when
my-
you have been appointed,
My lord, in the year 2023,
when you have been discharged. Petitioner, when the petitioner was discharged, sir? When the petitioner was discharged from the duty.
My lord, actually,
24th July
actually,
2023,
my lord,
appointment.
my lord, it is a contractual appointment and the contractual appointments cease by efflux of time, my lord. So that efflux of time ceases on 4th of September 2024, my lord.
4th of September.
2024. What has happened, my lord? She is not aware. I can throw the light on this. My lord, may kindly come to page number 33, my lord. Before that, my lord, I'll just explain. This is an ex-serviceman contributory health scheme, which has been established in 2002 after a lot of hue and cry from the ex-servicemen all over the country, my lord, and on the directives of Honorable Supreme Court, my lord. This is a scheme which is a contributory scheme, but completely under administrative as well as financial control of the government, my lord. There is no statutory rule. There is no law, my lord, for the appointment of the doctors or the staff in this, under this scheme. Under this scheme, there are a number of polyclinics, whether in military stations or even non-military stations, my lord. Basically, they are concentrated in areas where the ex-servicemen are living, man. So, like that, one such polyclinic is in Bengubi military station, which is close to the Bagdogra airport. Now, there they have 4 vacancies of medical officers and dental officer included. Now, they have reservation, man. That is a separate thing. That reservation also has to be tested on the anvil of 14 and 16, man. Nonetheless, I come to the thing that there are 4 vacancies and they can have only 60-40 ratio. 60% they have reserved for the ex-servicemen. Here the petitioner, that is the respondent number 5, sorry, for whom she is representing. He is an ex-service officer. He was a short service officer and he has not had a full-fledged innings in the services, my lord, in the army. And he is not a specialist doctor. He is a simple bachelor of dental services. So now 60-40 ratio, my lord. That means at the most, there can be 3 doctors from.
Sir, here after going through the document, this could find that the only one question is involved, whether the authority can place the one ad hoc or temporary staff by the another ad hoc.
My lord, it is not that, man. The question here, my lord, the critical questions there are different, man, and which are not determined so far as my understanding, man. The critical question is that here the government is the controlling authority of the ECHS, man.
Sure.
And by kindly come to page number 33, man.
You will not file the affidavit.
And and paying for extension. We have already received the entire documents and others. Lordship, only your lordship 7 days. The first day of June 10th, your lordship, you have found us. We have all the documents.
If on first day of 10th you will affirm, then when he filed the reply? When he filed the reply?
They are actually it is by design, my lord. It is by design that they come at the last moment and my lord.
Lordship, I will provide unaffirmed copy after completion to my talent.
How soon you file the affidavit? I will serve the copy to the counsel for the petitioner. Affidavit. How soon you file the affidavit? Will serve will serve
8 days, your lordship.
within 8 days?
Yes, your lordship. Within 8 days, the unaffirmed copy already I will submit your provide your lordship. We have already documents. In these documents, we find your lordship. The repetitioner herself appeared in the second selection process.
That's what I'm telling. If you wanted to argue on the merit, I will argue the merit.
Within 8 days, your lordship. Within 8
My
days,
lord, since you know it should be a fair play.
Yes.
I believe in fair play, my
Correct,
lord.
correct.
Level playing arguments. I also indulge in that, my lord. There's no, but in the interim, my lord.
Lordship, it
My
says-
lord, please allow me to, please allow me. My only thing is that whatever actions they have taken, even appointing respondent of 5 or ceasing to pay me, etc., that should be subject to the outcome of this writ petition.
But the question is that, na, that
lord.
you are not opting that order. 2 orders have been
My lord,
passed.
I had opted for,
Lordship,
I had opted, my lord, I have, when I say that any other order deemed necessary and fit for the ends of justice, my lord. So it covers, there are anything which cannot be conceived at that point of time, my lord. And which by their design, I am forced to seek this protection, my lord,
No, but
not otherwise.
But the last circuit, it is passed an order, na? Completion so and so, so and so. Considering the
It is
involved.
basically, they are frustrating their.
Kindly come to the order dated 9th April. Considering the issue involved in the writ petition and since the respondent number 5 has already been appointed, there is no scope for any interim order.
Lord,
Yes, my lord. This was, my lord said so. So I'm not seeking that order. I had said that his, in that interim order which I prayed, that his appointment should be terminated, man. Now, I'm not seeking that. I'm only seeking one order, my lord, that whatever actions they have taken, that should be subject to the outcome of this writ petition. That's end of it, my lord. That is a very, I mean, limited.
That always, if you win, if
My
you win,
lord, that is always there, my lord.
always,
My lord,
always,
That is always there, my
always the
lord.
appointment will go, then you will be.
my lord, the only thing is, my lord, you have seen me for 5 days. I am here in
That
Jalpaiguri.
like I find it that
And I have left every job in Delhi
what can be
and elsewhere.
done. What
And
can-
only because they have, if my learned friend is asked as to when did he get the documents, can he just,
So and so appearing for the petitioner, so and so appearing for the, you are appearing for the respondent number?
So 5 is mine.
1 to 4, your lordship.
1 to 4.
Lead by,
And so and so appearing for the respondent number 4, 5. You are appearing 5. Full stop. The counsel for the respondent number.
Lordship, kindly also record my presence.
yes,
Yes, DSG, yeah. And so and so appearing for, and the counsel for the respondent number 5 has filed affidavit in opposition. After serving the copy to the London counsel for the petitioner, let the same be cut with the record. Full stop. The counsel for the respondent number 1 to 4 submits that within a week from date, they will serve the copy of the affidavit in opposition to the London counsel for the petitioner. They will serve the they will serve the advance copy of the affidavit in opposition to the London counsel for the petitioner within a week from date. Full stop. Subpara. In view of the above, the petitioner is liberty to file affidavit in reply of the respondent number 5 as well as the respondent number 1 and 4 if received within a period of 2 weeks from the date of receipt of the, within period of 2 weeks, list the matter on and list the matter before the next available before the next circuit.
my lord, he is appearing for respondent number 1 to
1 to 4.
4 you, sir.
Yes, next. Who is for the petitioner? Yes.
I never mentioned the matter.
That's why, what is the case, what is Mohanlal Banerjee? It is the Mohanlal Banerjee, CR 11. And whose signature is this? Who is she?
This is another matter. Number case.
You have mentioned. Why? No, yesterday you have mentioned the case number 11.
Case number is this case number, but
Ah.
court title is another.
Correct.
Wrongly.
Though the matter is listed as to be mentioned. No. To be mentioned? Yes. कौन सा matter है? Though the matter is listed as criminal revision application. No, the matter is listed as criminal revision application at serial number 10. As per the mentioning list of the petitioner. But when the matter is called, comma, the learned counsel for, लेकिन ये किसमें देगा? ये तो फाइल ही नहीं है, क्या देंगे? छोड़. Okay, thank you.